The information in this video is not legal advice and is for educational and entertainment purposes. If you wish to seek legal advice, consult with a lawful attorney.
Hello, this is going to be the second video in the A.B.A. perspective, in which we're going to be going over the sequence of events in the criminal justice system. Now, if you recall from how we got to the glossary in the last video, it's pretty much the same path up to law-related educational network, except you're going to click on how courts work, and again, how courts work. And you can follow along with the website or whatever, it doesn't matter. Whatever's easiest for you. So let's start with the sequence of events in the criminal justice system. Now, criminal and civil matters are not the same thing. Civil matter, for example, is you are going against another person. For example, a child custody battle would constitute as a civil matter because you are in a dispute with another person and you're both going under the jurisdiction of the court to make a settlement because you and your spouse cannot make an agreement without the courts. Whereas opposed a criminal matter would simply be put as you being against the government or versus the government in a court matter, and there's generally a district attorney representing the government. So anyway, crime in this case, which is going to be the top of this list right here, is when you violate one of the government's statutes. Now, a statute by the A.B.A.'s definition is law enacted by legislatures or executive officers, such as codes. Now, it doesn't have to just be codes, like in the Napoleonic Code for Louisiana, for example, but in all the other states, there's acts as well, like the Drug Control and Substance Act, and there's also the Motor Vehicle Act. And if you're in contract to them with one of these acts and you go against these acts or one of the rules in our acts by performing a function of commerce, for example, you would then be in violation of a crime. Now, at this point, the crime may or may not have happened. That's why the crime gets reported. And then followed by the report comes an investigation. Now, an investigation is just them looking into the supposed crime, which may or may not have happened. So it could go unsolved and you're not arrested, and then you're done at that point. Or you might get arrested. So arrest by the definition is to take into custody by legal authority. Now note I said acts and statutes earlier, and this has everything to do with legal jurisdiction, not lawful jurisdiction. The two are quite different, because in legal jurisdiction there tends to not be an injured party, which is an argument you can actually make in court. But we'll get into that later. So an arrest can get you released without prosecution. And a prosecution, for example, is when you're in front of a prosecutor, which by definition is a government lawyer who tries criminal cases. Or you can be booked, which you go on record, and the same release without prosecution is possible. Now, after your booking, you go into something called an initial appearance, which is typically called your arraignment. Now, an arraignment is defined as the proceeding in criminal cases where an accused individual is brought before a judge to hear the charges filed against him or her and to file a plea of guilty, not guilty, or no contest, also called a preliminary hearing or initial appearance. Now, here we must ask, okay, what is a plea exactly? So a plea is the defendant's declaration of guilty or not guilty in response to the criminal charges contained in the information or indictment. Alright? So I want you to make notice of the word appearance here, because appearance by definition is the formal proceeding by which a defendant submits himself or herself to the jurisdiction of the court. So here's a huge clue right here. Up until this point, the court doesn't have jurisdiction over you. And what does that mean? So jurisdiction by definition is the power, right, or authority to apply the law, a court's authority to hear cases. So if there's no jurisdiction, then there's no power, right, or authority to apply the law, nor to hear the case. So the case must then be dropped or dismissed. Alright, so a dismissal by definition here is a court order terminating a case. It may be voluntary at the request of the parties, or involuntary. And a request is generally done with a motion, but we'll get into motions a little bit later. So, at this initial appearance, you can also be charged with a petty offense. Now, generally that would happen during a plea bargain. Now, a plea bargain is saying, or is the process by which an accused person agrees to plead guilty to some charges in return of the government's promise to drop some of the charges, or maybe even reduce some of them in that matter. So you'd be going to an initial appearance here to petty offenses down to a guilty plea in which you're sentenced, but we'll get into that a little bit later. But that's how they do plea bargains right there. Now, when a case or a charge is dismissed, that's saying that's your best way out of this whole circumstance if you're looking for a remedy to a traffic ticket or example or anything which is in one of their acts or statutes. Now, otherwise you'd be going to a preliminary hearing, right, which is a criminal hearing at which a judge determines whether sufficient evidence exists to warrant trying an individual charged with the crime. Alright? So, at this stage, your charges can also be dropped or dismissed if you make the right arguments in court. Otherwise, you'll be granted bail or detention, which you're going to be held for a longer date. And bail, right here, is security given for the release of criminal defendant or witness from legal custody, usually in the form of money. Note, it doesn't have to be money, so there's other methods to discharge this. Anyway, to secure his or her appearance on the day and time appointed, also called bail bond. So it's to secure an appearance, which is to secure jurisdiction under the court, or jurisdiction of the court. So they really want to get jurisdiction on you. If they can't get jurisdiction on you, they're going to have a problem. So we've made that much of an understanding out of this point. So let's get to the left-hand path that goes to misdemeanors right here. Now, misdemeanor is a less serious criminal offense, usually punishable by a sentence of 1 year or less. Whereas a felony, to the right hand here, is a serious criminal offense, generally punishable by imprisonment of 1 year or more. So the main difference, if you've been confused about that between misdemeanor and felony, is the time in which you can be imprisoned. Alright, so when you're going into your pretrial activities, this is the best time for you to make motions, which, to be simply put, is a request to the court. So, for example, a motion for dismissal. But again, we'll be getting into motions in more depth at a later video. But this is the time to do it, in which case a charge can be dismissed. And the same for felonies and whatnot. Or you can have a charge reduction coming from a felony pretrial activity, in which you're still going to trial. Now, if you remember, we got to guilty plea by making a plea bargain at the initial appearance for a petty offense, which got us to this point as well, which leads to sentencing. But a trial is where you're usually in front of a jury, and they will make a determination at that point, a judicial determination, or the judge will make that judicial determination whether you ought to be sentenced or acquitted. And acquittal, by definition, is a trial verdict that indicates that the defendant in a criminal case has not been found guilty of the crime charged beyond reasonable doubt. Alright, so after this point, generally you're going to be going into sentencing. Now, sentence is the punishment ordered by a court for a defendant convicted of a crime. So at this point, they've already convicted you. So if you pled guilty, you're already convicted. Actually, if you plead no contest as well, because you remember that's the third option of guilty, not guilty, or no contest. If you plead no contest, they're going to treat you as if you pled guilty. Alright, so keep that in mind before ever doing that. Now, in the misdemeanor end, you're usually given a fine for the sentence, and if you don't pay that fine, you go to jail. Or there's probation, which is a a sentencing alternative to imprisonment in which the court releases convicted defendants under supervision as long as certain conditions are observed. All right. So if there's a revocation, it can lead to jail. Otherwise, you're out the system, and if you go to jail and serve your time, you're out the system. Now, on the felony side, getting to sentencing, you also have probation, but you can get an appeal in order to get this thrown out. Now, what's interesting now about the felony side of the equation is you go to penitentiary. Anyway, where you have habeas corpus, right? Now, a definition for habeas corpus petition is saying in federal court, it's a means by which a state prisoner may challenge the constitutionality of his or her conviction and imprisonment. So if it's not constitutional, you can get it thrown out and you'll be out of the system like that. Now, likewise, you can get parole, which is the supervised conditional release of a prisoner, or that can get revocation and you go back to penitentiary. And afterwards you go out of the system, and likewise you can get a pardon, or you go to capital punishment and you get out the system eventually. So this is the general scheme or system of events which goes on when you're about to go to court, and I'm going to be going into more details about everything in later videos, and which I will see you next time.